Thanks, Leslie Curla. First of all, Leslie Curla, I want to thank Deputy Smith and our colleagues for giving the House an opportunity to debate this issue, which concerns retired persons in receipt of occupational pension benefits. The legislative proposal is premised on the idea that retired persons who are members of such schemes should be granted access to the state's industrial relations machinery. The rationale for this access is to ensure that retired persons are given notice are given advice in industrial relations processes for matters affecting their occupational pensions and other issues. I also appreciate that there is an argument that this necessity for inclusion in collective representation is based on the belief that pension entitlements are a form of deferred wages and that any changes affecting pension schemes are unfair to those retired workers. I fully understand that a number of former workers of semi-state companies feel aggrieved and that they may not have received their increases to their pensions in recent years. I didn't get a chance to engage with them yesterday at the Dáil Gate, but I have had the emails and the phone calls and the conversations with a lot of members as well, and I certainly will get a chance during this timed amendment to engage further on this issue with them as well. That the premise of ensuring that a person has a voice in matters affecting them is, of course, perfectly reasonable. And it is obvious that Deputy Smith and our colleagues have engaged extensively with retired persons and associations in preparation of this bill. And I want to commend Deputy Smith for this work and her interest in this matter. I know it's genuinely an effort here to bring forward legislation that you believe will have a positive impact, and I do accept that. It is clear that the proposal is attempting to address the specific concerns, legal term mischiefs, that the representative associations have identified to the Deputy with their issues, and this legislation that you brought forward is an attempt to address that. But the difficulty is, as a government, we have to look at the overall picture and the wider picture, not just their individual concerns. And that is why there will be a bit of time for us to tease into this and to work through this, and that's what the request for a timed amendment is about, that we can have that genuine attempt to look and engage right across the sector with this. And of course, it would mean engaging with those members themselves who would have protested yes and who have been contacting us. That's a natural part of the work we would do. Of course that would happen. But before I touch on the proposals concerning the Pensions Act, a policy matter for the Minister for Social Protection, I would like to flag some of the policy considerations in my own areas of responsibility and some of the issues that we have difficulty with and have concerns and have to try to tease through and work through, because it isn't just as straightforward as accepting their legislation here, while I accept it's a genuine attempt to deal with their grievances. Traditionally, industrial relations revolve around the relationship between workers and employers, workers' employees and their employers. A trade dispute means any dispute between employers and workers which is connected with the employment or non-employment of the terms and conditions of an affecting the employment of any person. The term non-employment has been extensively considered by the courts and is understood to mean dismissal, redundancy, or a person seeking employment with a given employer. A retired person is legally understood to be retired. A person cannot be, in legal terms, understood to have a dual designation of a worker and retired at the same time. A person is either one or the other, and a retired worker cannot actively be involved in a trade dispute involving matters of employment and non-employment. This legislative proposal is introducing a novel element to this established tradition, and it would change that. So it does need to be fully looked into and fully investigated and worked through. Industrial relations disputes involve a totality of the terms and conditions of existing workers, matters which do not in the main affect retired persons. The policy underlying industrial relations disputes resolution mechanisms in Ireland is to maintain industrial harmony and to ensure fairness in workplaces. A concern that we have to work through in our department is that the inclusion of a third category of participants to trade disputes with narrow singular interests in the collective bargaining process may distort the interests of those parties for whom the process is originally designed for. The inclusion of a third party to such negotiations may deter legitimate parties involved in the trade dispute from agreeing to engage in dispute resolution processes in the first place. This could have the unintended consequence of undermining the overall policy rationale for industrial harmony. And I know that's certainly not something that you want to do, Deputy Smith, so I'm not saying that's what you're trying to do. I'm just saying these are the issues that we have concerns with and have to try to work out. We must also acknowledge that currently there is no legal obligation on any employer to offer a pension scheme to their staff. The introduction of a legal entitlement for retired persons to have a seat at the negotiating table because of said pension entitlement might make occupational pension schemes less attractive proposition for employers. And that's something I know you don't want to encourage and we wouldn't like to see happen either. This is not a desirable policy prospect, and I'm sure it's not something that anyone in this House intends. And I'm not saying that you do intend that, I'm just flagging the issues that would have to be dealt with. It has already been recognised that there is legitimacy in time-limited circumstances for retired persons to seek redress from the industrial relations bodies. In 2015, the Industrial Relations Act were amended with the insertion of Section 26A to the 1990 Act. It allows a retired person to access the industrial relations bodies during a period of 6 months post-retirement for matters arising pre-retirement. This 6-month period is either from the date of retirement or the date from when it became known, or should have been known, the time frame in which to make a complaint for matters arising post-retirement. Section 26A was introduced to the 1990 Act to address the injustice where a person was unable to address work-related issues that may have come to light only after retirement, even though they related to matters that had arisen pre-retirement. It ought to be noted that there are exceptional circumstances where the Labour Court will extend the 6-month time limit associated with the date of retirement on a case-by-case basis, where the justice of the case so requires, and that's a decision that they can make. The second policy area within my own remit relates to the Trade Union Acts, which provide for the licensing of bodies carrying on negotiations for fixing wages and other conditions of employment. We have a concern with the drafting of this bill that appears to be suggesting that an entity purporting to represent the ill-defined category of retired worker, who may very well be actual workers themselves, could rely on the exemption to the requirement for a negotiating licence and ability to refer disputes regarding occupational pension terms to the industrial relations machinery of the state to seek access to public service pay negotiations. Such entities have no role in the determination of the terms and conditions of public service employees, nor the negotiation of any aspect of pay or remuneration. Any unintentional consequences of such an exemption needs to be addressed and worked through. Again, I'm flagging which of the concerns we will have here. With regards to proposed amendments to the Pensions Act 1990, firstly, scheme trustees already have duties and responsibilities under trust law, under the Pensions 1990 as amended and under other relevant legislation. The duties of the pension scheme trustees include administering the scheme in accordance with the law and the terms of the trust deed and scheme rules, as well as ensuring compliance with the requirements that apply to these schemes. Trustees must act in the best financial interest of all scheme members, whether active, deferred or retired, and must serve all beneficiaries of the scheme impartially. While Section 62 of the 1990 Act or the regulations made under that section do not currently specifically provide that member trustees must include at least one pensioner member, nor do they provide that member trustees must include one or more active members. They do provide an opportunity for such membership by either cohort or pensioner members may avail of the opportunity to become scheme trustees or nominate others to act on their behalf. The proposed amendment at Section 10 of your bill today would appear to give a guarantee of preferential treatment in the election for trustees of pensioner member candidates where such candidates have been nominated. However, as already stated above, the position is that once appointed as a trustee, such a person has a fiduciary duty to represent all members, be they active, deferred or pensioner, of a scheme impartially and act in the best financial interests of all members. If there is a conflict of interest, then a person's duty as a trustee must take precedence over other interests. Accordingly, any trustee who acts in the interest of pensioner members above the interests of any other cohort of the scheme would be in breach of this fiduciary duty. The proposed amendment does not provide for any guaranteed selection appointment in respect of other scheme cohorts, and therefore the preferential treatment of pensioner members provided by this proposed amendment could be viewed as inequitable or discriminatory, which again I'm sure is not something that you would like to see happening. If this proposal was accepted as it currently is drafted, the effect of the proposed amendment at Section 10 could result in a preponderance of pensioner members being selected to the trustee board over time to the exclusion of other member cohorts. Yet again, I am assuming that this is not the intended outcome that you would like to see. Regulations made under Section 62 of the Pensions Act are subject to Section 59A of the 1990 Act, which have been recently amended to require that trustees must satisfy good repute and integrity requirements on an individual basis and qualifications, knowledge and experience requirements on a collective basis. Accordingly, any amendment to Section 62 of the 1990 Act in general must be considered with the recent amendments to that Act in mind. Any guarantee in respect of the selection or appointment of pensioner trustees would have to be framed in such a manner as to ensure such pensioner trustees will satisfy those requirements, as otherwise such as a person or the trustees as a whole may be in breach of Section 59A of the 1990 Act. With the foregoing, the Government requires more detailed analysis and consultation about this legislative proposal. This bill introduces amendments that have wider consequences than those stated for the target audience. They must be carefully considered, but the government is willing to look at these issues. As I said at the start, I understand your attempts here are to correct their concerns, and it's a genuine attempt to do that, but we have a duty here as a government to the wider picture and to fully interrogate this legislation and see, and we are prepared to do that. And I genuinely am asking that you will accept our time amendment to give us time to do that. Thanks, Chair.